of our tournament where my friend John said he found a body in the bushes over there. I ran over there because I'm a healing monk to try and help, but obviously my magic wasn't strong enough because the dude's body was missing a head. So my friend decided to try and use a necromancer spell, which didn't work, which I knew it wouldn't. And apparently we contaminated the crime scene because that spell uses a lot of glitter.
Your Honor, I object!
And why is that, Mr. Reed?
Because it's devastating to my case!
I gotta tell you, you brightened my day, ma'am. All right?
That's what the last guy said, and then he sued me.
Good evening, everybody. Welcome back to the Brit Happens channel, where we focus on cases with indiscrepancies, where things are going sour, things are not right. And with me tonight is my good friend and yours, unless you're not a very nice person, Jason Broyles, also known as not Hailey Walbrecht. So welcome, Jason. So glad to have you back.
Thank you. I always love seeing you, Britt. So happy to be here.
Oh, sorry. I didn't mean to cover your face there. So
I don't mind.
So what we'll be doing tonight, everybody, is now that the hearing that you might have listened to on Monday is available on video. You can find just the stream of that hearing on Aidan Kearney / Turtleboy's channel. The name of the channel is Turtleboy Live. And we have our purple free Turtleboy background up for him. And very soon, I'm going to be doing a video that lays out the fine details of his case for those who are maybe not familiar. Maybe you were so busy paying attention to Karen Reed that you may not have had time to keep up with Aidan's case. So that is going to be coming available sometime in the next week or two. But yeah, let's say hey to the people. Yeah, it's his YouTube show. But thanks so much for the clarification, because sometimes I skip words because my brain goes a little faster than my mouth sometimes. Hey, Brit Gal, I'm glad you're here. We've got Debbie tonight. Hey, Debbie.
Hi, Debbie.
Martha. So glad to see you. And the Goodmans are here. Welcome back. Always glad to have you. And let's see who else we've got. We've got Nikki. Thanks so much for being here, Nikki. I'm going to change our seating arrangement, Jason. There we go. now we can see you. Oh, goodness.
I don't mind. I'm just going to make an assumption right off the bat that people would rather see you than me. If you want to flip it back around, it's fine. But
oh, no. And it won't be like this for long. We've got Sin in the house. Hello, glad you're here. Classic Overthinker has arrived, and it's a party now because we've got Mara's Beaver.
I've seen some of Mora's Beaver. Wait, let me rephrase that. I've seen some of the great tweets that Mora's Beaver leaves on Twitter. Does a wonderful job. So
yes, 100%. Let's go ahead and pull this hearing up because it's not a long hearing, but we have a lot to say. And one of the reasons that we're so excited about this is that we got to see Mark Bederow in full swing tonight. For you members of the channel, we do have a Bederow bat signal emoji. So if you'd like to be able to use this in the chat, feel free to become a member, or just appreciate the members who are using it. And for those of you who already are members, just a reminder that that emoji is there. All right. So I'm so thrilled because I feel like Bederow was kind of a mystery godfather to a lot of us who perhaps were watching Karen Read, and we would see Bederow give his commentary, but the majority of us had never really seen him go to town. So
I think that's right, Britt. And I think that it's such a big difference. Like, I mean, you almost knew, right? You knew because you can observe him and you can hear how he talks and makes the arguments. Also good to see you seize the day. And you knew he was going to be good, but you just don't quite know how they're going to command the courtroom until they get there. And I don't want to give any spoilers, but I think that the best indicator is the judge's reaction to him being in the courtroom. So I think we'll see that as we go. The other thing that I just want to point out at the beginning of this is I'm so glad we're doing this on video, because even though I was at the courtroom, I did not go inside. So I was outside and I was listening to this hearing audio only. And I love this because I love it when the screen comes up because I see all of my friends. So but I see like rows and rows of my friends. I know everybody that's currently on the screen, I think so.
And that just speaks to, the community that has been cultivated through, not just supporters of Turtleboy, supporters of Karen Read, and, just people who, I'm not even in Massachusetts. You're not in Massachusetts, even though you are from the New England area. But there are so many of us who, it speaks to the type of person you are when you see injustice occur at this level and with this brazen amount of just a lack of regard. Am I right, Jason? I mean, it seems
it is.
Like the perpetrators of the injustice don't even care how it looks to the public.
They don't. It's so egregious, and that's the word that always comes up for me, is because it's in this situation where you're like, why aren't they even trying to hide it? It's like, what? Yes. It's like it's so blatant and out front, and they're just like, you see when you watch them testify, when you watch these state police testify in court, the amount of disdain and contempt they have for the people to be able to just go up there and act like as cocky as they do. I'm speaking to you, Yuri Bukaki, and it really is like you see this happen and you're just like, what? It like someone needs to hire like a PR firm or do something along. And I know over the last couple of days, the colonel of the Mass State Police has been speaking and taking press questions, and he started to clean it up a little. And all I can say about that is I know he was new, but like, too little, too late. Like that should have started a long time ago, right in the beginning.
Yes. This should have been something where from day one, Colonel Noble was like a bull in a china shop, or should have been like a bull in a china shop. Just barging into every office and putting the fear of God in everybody for their job, because. And I would imagine that's part of why he was brought on in the first place. And so when you know that, right, it is. It really is. But, the best thing for your public image is what you do in your first 90 days in that position. That's no secret. So we saw a lot of ducking and dodging, I feel, from him in the beginning.
And nothing from, and frankly, I don't want to put the whole thing on him, because, what do we hear from the governor? What do we hear from the attorney general in the state of Mass? Nothing. We hear nothing. Right.
You're correct. It's a multifaceted problem.
Yeah, I was just going to say it's not even just that simple as the police union, which that statement is 100% correct. It's also there is a specific thing. I've talked about this before. I think I've talked about it on your channel before. There is this specific thing where we have this area of Massachusetts, especially in the counties surrounding Boston, especially Norfolk County, where you had the Winter Hill gang and you had this organized crime, and there was still a ton of government corruption, cops on the payroll. You can watch the movies and you can see that they had the Mass State Police, they had the FBI on their payroll, they had all of the basically politicians and police at every level were so wrapped into this. And when, with the demise of Whitey Bulger and the vacuum that was created in the Winter Hill gang, I'm sure there's still remnants of it, but they are not the force that they were. And in that vacuum that created, you still had all of these corrupt officials that were there. And it just seems like it was business as usual for them. But instead of getting their shots called by, Whitey Bulger and the Winter Hill gang, that they just took over and filled the power vacuum. Amen.
Amen to that. It's almost like when you see a hole there, someone needs to fill it. One of my teachers in high school used to call it the theory of, not a nice word, which is, basically there's always a classroom troublemaker, right? And as soon as he graduates, someone else rises to take that troublemaker spot. He may have never become a troublemaker, but because that one troublemaker left and there's an opening, someone starts, pulling the pranks and,
think of all the people that didn't become troublemakers because the spot was filled. See, I'm a glass half full kind of guy. So
yeah, true. Very, very true. You make a good point. All right, I'm going to go ahead and start the hearing, guys. Yes. Okay. I'll go ahead and say it. He called it the theory of turditivity. As soon as one gets scooped out of the water, another one rises from the bottom to take its place. But I'm going to go ahead and start the hearing. But guys, for those who are here, please make sure that you acknowledge the stream by liking, subscribing, doing all that stuff. Maybe even if you feel like it, share with a friend. This is not a secret club. Even if you're just here to troll, it actually helps your fellow trolls find this stream so they can also be trolls if you are to like and subscribe. So it does help get the word out.
I just left full screen because you said that, because if there are already trolls in the chat, I don't want to miss them.
Jason, you have a gift when it comes to trolls. I hope you know that.
Thank you. I appreciate it.
Here we go. All right. So Commonwealth versus Aidan Kearney, July 7th, 2025.
7 and 17, 26 and 7 on status, and 17 and 25 CR 8 is on.
Here's Courtney.
Good afternoon, Your Honor. Robert Cosgrove. Good afternoon. Hello, Your Honor. Timothy Bederow.
Let me just say the irony, before we really get into it, the irony of Auntie Deb looking up like he can't see over everybody else already.
I know, it is funny, and it's like these three lined up in height order, so like it's like a ramp down, and not a lot of people, I think people know now because people try to use it to make fun of Bederow. For someone who is small in stature, he is such a large personality, which is why I love that. So it's just,
yes,
he's people look at him, and I'm sure every time he walks into a room, they underestimate him, and by the time he leaves, they definitely do not, because he makes himself well known. So it is, and I can tell you it was random. It just happened that way.
Yeah, it was, but it is the catalyst for the birth of the possible purple free Turtleboy support color.
I want to say one more thing. I want to say one more thing too quickly, Britt, which is, we're all Bederow fans because he was our color commentator throughout the whole Karen Reed trial, and we saw him every day. But I am a huge Tim Bradel fan.
Oh, me too.
Because first of all, he's always on. Like if you talk to Tim Bradel, he's super sharp. He's on top of it. He knows exactly what he wants to say, and his respect for the Constitution. You and I already bond over this issue in that we're both, First Amendment advocates and purists in a way, and that's Tim Bradel in real life, not just when he's representing a client or a lawyer in court.
Great, and I've definitely picked that up from Bradel as well in the handful of interviews that I've seen, and he seems very sincere to me that this is stuff he really has a heart for. So, I mean, Aidan could not have done a better job in finding the right team for him, which is so important. But Bradel is representing Aidan's position in such an amazing way. I love when Bradel gets really fired up too. And he's ingenious.
He is. He makes good arguments on the fly, which I love. And I think you'll see the same thing with Bederow, where if something is thrown at them, it really is like at the snap of a finger, they can pivot into another argument that is competent and sounds like they, prepared just as long for it. So they're great. They're both great litigators. So they're both great attorneys in court. There are some amazing attorneys out there, but that's a separate skill. It's the Alan Jackson skill that we see when he's in court. He commands the courtroom,
Yes, 1,000%. And yes, the level of preparation you need to be able to make those in the moment pivots is wild. I mean, you have to you have to have the same amount of knowledge, if not more, as though you were there for whatever alleged incident.
We're holding everyone up, but you can't you can't fake it. You just can't fake it. You either have, and we saw that in the Karen Reed trial with Adam Lally when the time was wrong. He was talking about it being daylight. It was a daylight savings time. It was a Scrivener's error, and it's daylight savings time. Or the cameras at the library were motion activated. Like all of these things that they made up on the spot weren't correct.
Yes.
So when those come out in court and they're not correct, they're stating them as fact, and it comes back on the other side. And as an attorney, you look horrible, and you can't fake it. We know that you didn't do your homework. We know that you didn't have the answer, and it would have been better for you to say, "Let me look into that and get back to you because I don't know the answer."
Right. It shows.
But when you know your facts and you've anticipated all of the arguments that might come in against you, and you've done these things, it really becomes so much better. You can tell the years of experience pay off.
They do. They absolutely do. Let's watch them work, guys. We've got the Killer Bees.
On behalf of Aidan Kearney, to my left.
Good afternoon, Mr. Kearney.
And Mark Bederow, Mr. Kearney.
Hi, Mr. Bederow. Good afternoon. Okay, let's arraign him on the new case.
On May 13th, 2025, the grand jury sitting in the county of Norfolk returned indictment number 2582CR00088 charging as follows. Offense 1, charging intimidation of a witness, and offense 2, charging intimidation of a witness. Do you wish to waive reading of these indictments?
Yes.
How do you plead to each of these indictments?
Not guilty.
Thank you, sir. Is there a question of bail?
There's no question of bail, but I would ask the court to...
That face, he was expecting Cosgrove to want to take away the bail.
Court, withdrawn, I believe it was no contact with the alleged victim, staying 100 yards away from his place of work.
Let's see if I can get
What are the allegations on
subtitles.
on this one?
There we go.
Intimidation of a witness, Your Honor.
Yeah, but what's the nature of it?
This was the parents outside.
Oh, outside
the
the
shop.
Wait a minute.
Yes, right, yeah, I remember.
Judge, that's agreed under section 86.
Yeah, that's fine. All right. I'll close that, Margaret.
Thank you.
Can you do that now?
Why don't you do that now? Just.
Mr. Kearney, the court recognizes a person without assurance the following conditions. You have no contact record of particular mistake. You are to stay away, have no contact, stay away 100 yards from the residence and the place of work of the complainant. Consent to those conditions, sir?
Yes.
You hereby notify your charge of crime or appear at your release. Bail and this matter may be revoked in accordance with maximum law. 276 section.
All right, what else are we gonna do?
Judge, if I may jump in right there, just for the record, we filed 2 arraignment-related motions, Your Honor.
Okay.
Obviously, we can push those to another day with 2 small exceptions of just an order to preserve notes of investigators and to preserve video, if I may, Your Honor. I don't believe there's an objection.
Okay. There is not. Yeah, those are both, so we sought, the Commonwealth sought to preserve notes of investigators and to preserve video. What else can I do for you?
For me,
I would have a bourbon.
Why don't I start with you, Mr. Cosgrove? Go right ahead.
So Your Honor, entered a discovery order the last time you were here. I made substantial progress on it. I can't say I fully complied with it, but I have about, let's see, somewhere in the neighborhood of 5,000 or 6,000 pages of discovery to provide Mr. Broyles today. And I had planned, Your Honor, to file that with a motion for a protective order, which I had served on Mr. Broyles a couple of nights from Mr. Broyles. And we have been going along with these essentially tracking protective orders in the Kearney case, and in fact, much of the material is duplicative of discovery turned over in the Kearney case, and I pretty much followed a form protective order.
So we have a substantial discovery dump so far. I'm gonna bring the speed up a little bit. And Cosgrove is asking for more protective orders. So that means that the public cannot see what gets turned over from the Commonwealth to Aidan and his attorneys. Aidan and his attorneys can see it, but it cannot be released to the public.
And I just want to make it clear here that some of the stuff that some of these materials that we're talking about and the things that they're asking to be turned over are communications that basically allege misconduct on behalf of the district attorney's office and some other things. So when they're asking for a sealing order because they're asking for a protective order to protect a certain witness from maybe harassment, or they're trying to do these things, that's one thing. But we are bordering on a lot of these requests, and I think you're going to hear the attorneys make some arguments not far from what I'm saying here.
Yep.
We're bordering on a lot of these requests of the government just trying to hide its own misconduct, and that's not what these protective orders should be for, these sealing orders. They're not there to protect the government from embarrassment because of the poor decisions that they made, let's say, in hiring Ken Mello to be a special prosecutor or things, or his communications with others. Sorry, go ahead.
Right. They're there to protect individuals, to protect children. If there's some kind of a safety concern for the defendant or a victim, that's the purpose of these protective orders. But the Commonwealth wants all the benefits.
They sure do.
And all the resources. So, come on. What's going on with my mouse? Here we go. I have one of those Bluetooth mouses that goes to sleep.
Oh,
is the plural form of mouse still mice when referring to a computer mouse, or is it mouses?
No, I think it's mice, and I think that you do you have to say do you have to say blue teeth mices? Is that
blue teeth?
Yeah. Just wondering if you had to pluralize them both.
That makes me happy. I'm going to go ahead and do it now.
These have all been allowed with the agreement of the defendant and without prejudice.
Okay.
I understand that Mr. Bredel wishes to bring that practice to an end as of today. I'm in a somewhat different position.
Let me hear from Mr. Bredel. Mr. Bredel.
Thank you, Your Honor.
Give me your answer.
I appreciate it, Your Honor. Judge, the Kearney case is over with. It's moved. It's gone. Okay. And my filing, Judge, entitled Aidan Kearney's motion to release case documents from impoundment is what we're talking about here, Your Honor. So I asked the court last time, and we had so much business on the docket last time, I don't think we've circled back on it. But I was asking to just release everything from impoundment, Your Honor. The fact that things are embarrassing or scandalous or cause negative light to be cast upon public officials, Your Honor, is not a reason to impound documents. It's actually a reason to release documents. And that's really all the Commonwealth has left on the existing stuff, is that, gee, this might make investigators look bad. This might make special prosecutors, present company accepted, look bad. This might, cause.
Bredel is such a gentleman, by the way. He wanted to double back and say, not referring to Mr. Cosgrove here. We're talking about other special prosecutors.
Right, and it's the same characteristic that we see in Alessi. He's going to be a gentleman. That's and not far off from Bederow either, unless you make him mad.
Correct.
He's going to be a gentleman in court, and this is I may have always wanted to be a lawyer, but this is one of those areas where I'm not sure I would be good at that in terms of being able to maintain that demeanor and not, you see my tweets. I'm going to pretty much call every opposing lawyer a moron.
Yep.
So when I see them do it, I respect it, and them.
Which is why we're here with the CPO, the Court of Public Opinion.
Right.
I don't belong in a courtroom every day either. I may be able to watch my words, but this face will get a bitch in trouble. Karen probably has nothing on me. My husband laughs at it all the time. He says things like, your face is being too loud and stuff like that.
Oh, that's funny.
Election shifts, and that's not a reason to impound things, Your Honor. And initially, we have sort of taken the.
Did you hear about that? Did you hear that part?
About the election shifts?
Is that, gee, this might make investigators look bad. This might make special prosecutors, present company accepted, look bad. This might, cause election shifts, and that's not a reason.
Let's see. Can we think of anybody who's up for re-election in the next year or two?
So what makes you're saying this, but I can't. I'm watching this, and all I'm actually watching is right over Bredel's right shoulder is my friend Erica Walsh sitting there, and
I see
I'm watching her reaction. Like, if you go back one more time, I think you have to watch it.
Here, let's see if I can zoom in on Erica just a little bit. Oh, nope.
She's just she's just animated in there, and it's funny to watch.
Okay, if you can see my cursor, I'm highlighting Erica right here. I'm circling around her. She's in the black tank top, and her hair's pulled back.
Excessive look back. This might, cause election shifts, and that's not a reason to impound things, Your Honor. Initially, we have taken the candy from, from the Commonwealth.
And this is what you can't get from the Zoom calls.
It's true.
Right?
When they say, we'll give you the stuff, but just agree to this protective order. So we want the stuff, but at some point we have to get off of that train, Your Honor. This is a case of immense public interest. It's a case of, First Amendment issues. And I know we may.
Oh, all right. We got to do the super video. Thank you so much, Nan. Gallagher, wow. Everybody.
Nan's the best.
Mighty, the noble, the honorable, but full of grace. Nan Gallagher.
Nan
so glad
Gallagher
that you're
was
here.
I think I'm rubbing off on Nan. She was slaying trolls on X today. It was amazing to watch. I was having a good time.
I had the privilege of witnessing a bit of it myself. Thank you so much, Nan. I appreciate the support. It's always good having you here. So thank you so much. Oh my gosh, Thomas just called you Nana Claus.
No, Thomas, no.
I prefer Nantastic.
There you go.
We're gonna go with that. All right. Oh yeah, feisty and fabulous. Yes. Shannon Burgess's 2050 senior yearbook. Okay, Debbie Joe. That's an awesome YouTube name. All right. Nan, I got to ask you, while you're here, I noticed that you changed your username to the Lawfario official. Are there imposters arising? Is that a thing? Is someone pretending to be you who's not? I was just curious about it. So, all right. Let's keep going with Bradel and his glorious arguments paired with the glorious facial expressions of Erica Walsh.
Disagree on that, but that's what our adversary system is for, and that's okay. And I think every case that eventually gets to the SJC or the Supreme Court starts with a trial judge maybe not agreeing with it, so that's okay. And that's what we have here. But in any event, Your Honor, I think we can agree that this case brings to the fore really important issues about what is witness intimidation, what is journalism, where does the First Amendment fit in, and these text messages about and I'm trying to not speak of them in open court, but we all know what they say, and we all know that there's a public interest in shining some sunlight on these things. So we're not asking to publish someone's address or someone's phone number. We're asking for the content of these communications that these folks have issued between and among each other. And the content of them per se has no persuasive power to make you want to impound.
Let me ask Mr.
Precisely.
Cosgrove, what interest at the moment does impoundment serve?
Your Honor, I've just been handed 20 minutes ago a fairly extensive motion suggesting that I have all kinds of various burdens to justify impoundment and citing a lot of case law.
Are we going to get a non-answer? What do you think, Jason?
Yeah, but we're already in the
getting a
middle of it,
non-answer
for
here.
sure, yeah.
Yeah. So far, I'm hearing, 5,000-6,000 pages of discovery, burdens, case law.
I just want to comment on Nan's last message there. She changed her name because she's getting spoofed in chats, but nobody could ever spoof Nan. No, we're never gonna fall for that. So.
Oh yeah, I would know the difference.
She's
in the blink of an eye.
She's one of a kind.
Amen. Amen to that. Hey, Ruth Ann, thanks for being here. She's done with her walk. She was walking and listening earlier. I saw that in the chat. So this is kind of a lot like what we were talking about a minute ago, Jason, how a good lawyer can make an argument, a great lawyer can make an argument on the fly and make those changes in the moment and pivot, being the operative word.
I agree. And you have to ask yourself, why is he delaying and why is he kicking the can down the road? This isn't just an attorney, right? This was a judge who worked in these same courthouses. Like this was he should have a command of the facts way more than a regular attorney would, because he was the one that was making decisions on sealing motions. He was the one that actually had to have these arguments made to him. So he should have these arguments at a moment's notice to be able to come back. Maybe not case law. I'll give him that, right? Like if you're going to come back and expect him to cite precedent on the spot, like, okay, great. You should need to do some research, but the actual, the argument, like he should have the argument down pat, like at a moment's notice. And the truth is it leads you to question, do we have a problem where he has to go back and get some marching orders? Like, is this a problem where he's not truly an independent special prosecutor? That's the question.
And furthermore, it's not like Robert Cosgrove is, belated in case law. he has come out of retirement to do this. So this case, and possibly one or two others, is his entire workload. So it's not as though he's swamped and juggling a bunch of cases. This has gotten his undivided attention in all likelihood. So
and he still has, I think what people don't realize, and I don't think they realized it about Hank Brennan until late in the trial was the first time it was mentioned. They actually give them, he's got a paralegal. He's got staff. Yeah. It's not just, it wasn't just Hank Brennan, and it's not just Robert Cosgrove. He has access to someone to assist him with this legal research. I don't know if it's someone he brought or it's somebody that, the DA's office is supplying, but either way, it's not that difficult. And I think what you'll hear later in the hearing is, having been to a bunch of the hearings in this case already, this is just like the start of the Karen Reed case, where there's years-long delays in discovery.
Precisely.
Where they just keep asking for the same things over and over. And Cosgrove shows up at this hearing and wants to say, oh, look, I've got 5,000 or 6,000 pages. Oh, yeah, great. We've been asking for these pages for years, and you're not even making a dent in the volume of discovery that's out there. So, sorry,
and
go ahead.
This is what comes from two things: overcharging when you don't have the facts or the motive or the underlying case to back it up. And the second thing is, when you prosecute too early, when you bring an indictment too early and you haven't really built your foundation and you're trying to build a case after you started it. I understand that a lot of the time discovery is like a living thing, right? It's constantly coming in, getting allowed, getting, all that. But you need to have your building blocks before you bring an indictment like this, because what Robert Cosgrove's response right now is telling me is that, one, he doesn't believe himself that this should be impounded.
Right, it's his motion.
Exactly.
He's not just responding to their motion, it's his motion. He's making
motion.
the motion to seal it, and he doesn't even know why.
And he can't make an argument even to back up his own motion. And
right.
B, that, like you said, it does bring the question of, does he need to consult with somebody before trying to back this up? So yeah, he's just asking for more time.
There was a little nuance that I don't know if people noticed when he was talking about the motion. He was saying, I basically just used the form of their motion. You see this thing when they don't believe in what they're saying, he is throwing in a little disclaimer in there. It's very subtle, but he's saying, oh, I basically just used the form of the motions from the Reed case. Like, they're very similar to that. And I use their motions because he's essentially disavowing personal responsibility in that. And so, lawyers speak, right? You have to listen to everything, and you have to listen to the details in that. So he's throwing that in there. He's basically saying, don't blame me for this. But
it's the copy and paste fallacy.
There you go. There you go.
Oh, man. Yeah. I mean, it's crazy how there really is a common denominator with a lot of the misconduct, conflicts of interest. There's definitely a recurring theme here.
Various burdens to justify impoundment and citing a lot of case law. I would like an opportunity
to
file.
I think it was a week enough.
I'd like a little more than that.
About 2 weeks.
All right.
I'll give you 2 weeks. I'll take it under advisement. And if you want to file anything else, Mr. Bradle, Mr. Bederow, you absolutely have every opportunity.
Thank you very much.
Okay.
Now, Your Honor, with respect to the items that I was going to turn over today.
So I'll allow the motion, Mr. Bradle. I'm not there.
Sorry.
That's fine. You got to talk to your client. You got to talk to Mr. Bederow. My point is this: if you want to stop.
Very different from Bev's grave concerns, by the way.
He is. I mean, Doolin is a breath of fresh air. I've seen him in person in court, and he really is. Even when he's in a bad mood, he's very different than Bev or whatever else. So you can see it. At this day, he obviously was in a good mood. He was jovial, joked right from the beginning. Oh yeah, the making faces at the pizza shop case. You know what I mean? Like
and points to him for the graph paper shirt too. That's sharp.
There you go.
I'll allow it without prejudice. Sure. And then I'll see what you have to say and what Mr.
We have to take the candy.
That's fine.
Please note our objection. Thank you.
Yeah, no, that's fine. So I will allow Mr. Cosgrove's motion without prejudice. And I'll take any submissions that you have, and I'll give you a final answer probably in about 3 weeks.
Thank you.
Does that make sense? Okay.
Thanks, Baza.
Judge, just to shift gears a little bit, there's some outstanding discovery that we've been talking about.
Yeah.
And I want to start off, I know that the court's time can be much better spent in discovery this week. So we talked about the idea that we would go to the DA's office, and to the extent there's items that the government says they've given us that we can't open up or figure out,
yeah,
you know, I think we're going to agree to go in person with our people and figure it out. So
sure.
That's the first thing I want to say. But then, in addition, Your Honor, there's the this inventory that I filed. It's entitled Inventory of Outstanding Items in connection with our third motion to compel. There's about 10 things, Your Honor, and I think, unfortunately, that the government ought to go through and answer to us today about what the status of these things is. And we've been kind of going back and forth about these things for a long time. I looked back, Your Honor, and my first discovery request was February of 24. And second and third, you know, were the months following. And you know,
here's to hope.
Fairness, counsel was not the prosecutor of record at the time, but you know, the rules are the rules, and we need this stuff, and it's gone on way too long. So these are the 10 things that I think are very important, maybe 9.
Mr. Cosgrove, might you want to take that 2 weeks and respond to all of those?
Can you give me an extra week?
An extra week.
Okay.
All right. But it is, Mr. Bederow makes a very good point. As we all know, I think that it's important that the discovery be turned over so that we can bring a timely trial to the case.
I don't disagree with Your Honor. Notwithstanding that Mr. Bederow has some complaints, and some of them may well be legitimate, there has been a substantial amount of discovery turned over in this case.
Yep. If you turn it over 5,000 pages today, it's a lot of discovery.
We appreciate it, Your Honor.
Okay, great.
Thank you. And Attorney Bederow has a number item as well.
Mr. Bederow.
Thank you.
Oh, goodness. So was this Bederow's first appearance before Doolin?
I don't remember who, you know, actually, this is so crazy because in the case of both of these hearings, I was outside. So, but the first hearing back in September of 24 that I attended in person, and this counts either in the Karen Reed case or in Aidan's case, is the first, because it was directly after my identity was exposed. Yes. I remember this. I remember showing up on the sidewalk to this really weird thing because people knew who I was, and I wasn't used to people knowing who I was, and they knew me before I knew them, and I didn't know anybody. And when I showed up, I saw, actually, the first person I saw was Richie Microdots. I knew who he was, but as I walked around the corner, people looked at me and they started like whispering. I saw them talking to each other and I didn't know what to do. So I walked into the courthouse. I went to the clerk's office and I made a records request because that's what I do. And then I came out and finally someone like walked up to me and they're like, "Are you?" And I'm like, "Yes." And then all of a sudden, then the floodgates opened and everyone came over and, you know, you're all kinds of random people are hugging you. You know what it's like to be there, right? Like you have this sudden, suddenly and I love it and I would never look back, but that was the first time I saw Mark Bederow as well. So he was there, but I don't know because I didn't make it inside. And in this hearing, I can tell you for this hearing, I actually wasn't going to go. I had made the conscious decision not to go because it's billed as an arraignment, right? Like in arraignments, you saw how long the arraignment portion of this video took. It was like 4 minutes and the arraignment was over. Because that's all you do. They read the charges, the person pleads guilty or not guilty, and bada bing, it's over. And so I said, am I going to invest the 2 hours to drive down there for that 4 minutes? And then at the last minute, I just suddenly, I kind of panicked. It was I think it was an afternoon hearing, so I could even get there. But at the last minute, I just said to myself, after the news on the weekend from the Cape and like all of this stuff that happened there, I said, they're going to try to file another impoundment motion. And then I'm like, I have to get there. Then I'm like, I have to get there because if they revoke, a bond revocation. And I'm like, because if they revoke his bond, like, I feel like I might need to do something. Like, I'm going to have to get online. I'm going to have to talk about it. Things are going to happen. It's going to become a big, big story. And I want to be there.
You want to be there to document it just in case.
Not just that, but I actually want to be there to assist in any way that I can. So if anything needs to happen, like I make no bones about it that I advocate for Aidan Kearney in this case specifically because of what they're trying to do for him. So not just covering the story or whatever else. I wanted to be there if they needed somebody to do anything.
Sure.
Do you need me to go make copies while you file emergency motions? Like, I just wanted to be there. So I made the last minute decision and I texted Meredith and I'm like, hey, you know what? I said I wasn't coming, but I'm on the way. And so that's why I didn't get there in time to get in. But I was good because I was like, I don't need to be inside to fulfill that role if something goes wrong or something happens.
Right. So. Exactly. Well, I'll tell you what, one of these days I'll come up for a hearing and we will both get in that courtroom. Come hell or high water.
The one thing I'll say before you hit play again is that it actually all worked out because, my friend Tima.
Yes, I met him the last time I was up there and he's so sweet.
Tima's the best guy ever. And it was the day before his birthday. And there was a little gathering for him at the Monday night, dive bar pizza thing. So I would have missed his birthday party had I not come up because I didn't. No one thought to tell me because they're like, well, you're all the way in Connecticut or whatever. You're not going to be coming up for Monday night dive bar. And when Erica Walsh saw me, she goes, "It's so good that you're here because this is happening." And I was like, "Yes," because then I could show up and surprise them. Hi, Mary Bagwell.
Hi, Mary Bagwell.
Hello, my friend Mary.
Glad you're watching. Glad you're here. We need to talk soon, by the way, ma'am. But all right, so let's keep on this.
We appreciate it. Okay, great.
And Attorney Bederow has a number item.
Mr. Bederow.
Mr. Bederow.
Just going back briefly to some of the issues about impoundment.
Yeah.
There are some items that are currently under impoundment, which we believe ought to be released from impoundment. Specifically, messages from Michael Proctor and a civilian witness. Those messages were cited in our motion to dismiss. As the court is no doubt aware, Michael Proctor is terminated from the state police. He has been a matter of public interest with his involvement in both the Karen Reed case, which led to Mr. Kearney's interest and ultimately, on some level, his indictment in this case. But also, those messages were impounded ostensibly for privacy interests, security interests, those sorts of things. Recently, Michael Proctor has been on a press tour on ABC News and NBC News, vigorously defending his investigative conduct. The messages...
Yeah. This man doesn't give a damn about his privacy.
And you know what, Britt? Actually, if just back up like 5 seconds and watch. So, we have the attorney area over here where there might be attorneys waiting for other cases, or they could be paralegals or whatever else. But the woman that is sitting directly off of his left shoulder there, watch her when he's making that argument. Just watch her.
Okay.
She's not involved in this case, as far as I know.
All right. So with the kind of lilac colored dress and the jacket.
Yes.
Okay.
She appears on screen directly to Mark's right.
Recently, Michael Proctor has been on a press tour on ABC News and NBC News, vigorously defending his investigative conduct. The messages that are at issue here, which are impounded, the public is entitled to see that. There is certainly a presumption.
I think you have to go back up just a
little further,
a tiny bit further. Yeah.
Okay.
Yeah.
All right. Here we go. I went back about 20 seconds.
In this case, but also those messages were impounded ostensibly for privacy interests, security interests, those sorts of things. Recently, Michael Proctor has been on a press tour on ABC News. And ABC News.
She looks right up and over.
And And she actually nodded. There was a section in there where she nodded when he started to see it, and you can see it was involuntary. It's one of those things where when someone's talking and you get this going on, she did this involuntary nodding thing, and then she caught herself.
Oh my goodness. That's an interesting observation. See, again, this is why it's so great to have the videos.
I agree with you, and these are the things that I watch because I don't need to see what Mark Bederow's doing. I watch what's happening around. You know what I mean? Like it's and I wish they had a camera just on the judge. You know what I mean? Because that's what I really.
Oh, me too. Like, you know how Law and Crime had a camera on Karen and her defense team. I mean, constantly. I wanted a Bev camera. Yeah, I'd like a dueling camera too. I want to see what makes him smirk, what makes him chuckle, when he starts to kind of lull off into La La Land and
yeah, and it's funny when you talk about the difference between hearing the thing and seeing it. That's also the difference between seeing it here and seeing it in person. Because in person, you can gauge what's happening on the bench when they're in sidebars, when they're doing all of this. You actually get a better impression of what's happening all around you versus, you know, where the cameraman chooses to focus at any moment.
1000%. Thank you, Morris Beaver. So guys, if you haven't already, please leave your Touch DNA on the like and subscribe buttons. And consider sharing with a friend because this is not a secret club.
This makes me I don't know who this is. But whoever did that is a genius. Because that literally is the story of how Hailey came, that there was this Jimmy 2 times troll.
From Goodfellas?
Yes, most of his memes were that as well. And Hailey was a social experiment because he got my prior 2 accounts canceled. And when I came out with the Hailey Walbrecht account, it was so that I could talk exactly the same way to this Jimmy 2 times and wait to see if he got my account canceled. So whoever did that, bravo. That's a genius comment. And if it really is you, and if it really is you, Jimmy 2 times, leave the girls at the Hooters in Shrewsbury alone. They do not like you. Sorry, go ahead.
Vigorously defending his investigative conduct. The messages that are at issue here, which are impounded, the public is entitled to see that. There is certainly a presumption of public access to those files. Michael Proctor has surrendered any privacy interest he has by addressing those issues, as has the other civilian that we're talking about, who also recently appeared on national news with other members of her family defending her and her family's conduct in this case. Those messages should be publicly available. If there's going to be information that's in the public realm, there's no reason why information that the prosecution wanted concealed from public view should be concealed any further. If the court likes, we can approach and show you the messages. I would suggest they are relatively straightforward, and there's no reason for those to be impounded.
So we all can probably take a guess as to who this civilian might be. There's only 1 or 2 people that it possibly could be, but I am at the edge of my seat waiting for these text messages.
Yeah, and I think as you play on from this point, I think it gets even more clear who it is. Yeah.
Missy, so glad you joined us tonight. Thanks for being here. All right.
Missy I want to just really quickly, I think there is a standout for Sandra Birchmore on the 12th this weekend down in, I think it's, Missy, put in the chat where it is. Maybe it's in Stoughton.
I can check on X real quick.
Yeah, I just wanted to throw it out there because I'm not going to be able to attend, and I really wanted to go. So I want to make sure that we tell everyone. So if anyone's in the area, they can make it out there.
So, oh boy, I should have brought my reading glasses, Jason. Okay, yes, it is on Saturday the 12th from 12 to 3 at the Stoughton Center across from Town Hall. That is 10 Pearl Street in Stoughton, Mass. Please wear light blue or white or both to show your support.
Love it.
Anything you want to say to that, Mr. President?
Captain said, Mr. President.
Well, I would suggest it would make sense to take this up when we take up the.
I think that makes sense.
I won't ask for another day.
Why don't I do this? Why don't you all come up the sidebar? Let me take a look.
Have your shit together, please, at this next hearing. Oh, okay, good. It skipped right past the sidebar.
Yeah, probably smart.
Oh, wait. Did it or did it not? Because I'm hearing... Nope, it didn't. Dennis Sweeney!
I know, this is why, I actually am okay with the crowd watching here because...
Oh, Dina! Here, I'll just mute it.
Dina, Jack... Oh, they're back already.
All right. Yeah.
He must have...
No, the sidebars are really brief in this hearing, and I did skip just a hair.
Longer.
I skipped just a hair too, but that was before you said you enjoyed the crowd watching. So
one outstanding issue relates to the second of the three indictments that relates to Lindsay Gaetani. We moved and were granted a hearing to disqualify Mr. Mello from prosecuting that case because he is an essential witness in that matter. That issue was decided.
Guys, if you have wandered off into La La Land, wake back up and listen to this. This is going to clue you in a lot about Aidan's case.
That relates to Lindsay Gaetani. We moved and were granted a hearing to disqualify Mr. Mello from prosecuting that case because he is an essential witness in that matter. That issue was decided in September of 2024. A hearing was ordered in January of 2025 for reasons which the court is familiar with. That hearing has been put off. Nevertheless, we're looking to move this forward, and the issue is not resolved, and we're led to believe that Mr. Mello will not voluntarily withdraw. For whatever reason, we need to do this hearing. We believe that he's going to be a defense witness in this case. Getting discovery between him and another civilian witness today, which I think is going to further that application and very likely make him even more a prosecution witness. And we just can't kick this can down the road for close to a year. So we would like to schedule a date for Mr. Mello to either appear, be examined under oath, explain the consequences, which the court, again, is probably familiar with. Was contacted by the complainant during the alleged crime repeatedly, 4 or 5 times over the course of that day. Instead of the police being called, he was an ear witness to these allegations. Respectfully, he needs to come in here, answer these questions so the court can issue a decision as to whether he's going to be allowed to continue or whether we can go through the process of subpoenaing him and any other items that might be of assistance to us.
Okay, so for anyone not familiar with what Mr. Bederow is referring to right now, on the day that Aidan, well, allegedly, had some type of physical contact with Lindsay, which in the opinion of the Commonwealth was assault. Okay? On that night, the night that it happened, the fake victim
Britt froze. Hi, everybody. I don't know if you can still hear me, but I certainly can't hear her.
Okay. Oh my gosh.
Welcome back.
I don't know what happened. Is there 2 of me?
There is?
Yeah, I don't know what that was. I did hear some thunder a minute ago.
I didn't know. The worst part is I didn't know if anyone could hear me because I would have just continued on, but I was
Right.
This reminds me of a Spaces I was in with Meredith a week ago or whatever, where there was a lot of technical difficulties and it became like can anyone hear me? Can anyone hear me? Like everyone saying, can anyone hear me?
Was it the one with purple Kool-Aid drinker?
It was. And by the way, there's probably nobody in the world who is more thrilled about the potential purple
Amen.
than purple Kool-Aid drinker.
Amen to that. I've seen some of that thrill firsthand. Okay, so it closed everything on me. So I'm restoring the page. If I'm not in the exact spot that we were at a few moments ago, I do apologize. But Bederow is worth hearing a second time. So
I agree.
Here we go. It's back up now, y'all. Thanks for your patience.
To disqualify Mr. Mello to prosecute in that case because he is an essential witness in that matter. That issue was decided in September of 2024. A hearing was ordered in January of 2025 for reasons which the court is familiar with. That hearing has been put off. Nevertheless, we're looking to move this forward, and the issue is not resolved, and we're led to believe that Mr. Mello will not voluntarily withdraw. For whatever reason, we need to do this hearing. We believe that he's going to be a defense witness in this case. We're getting discovery between him and another civilian witness today, which I think is going to further that application and very likely make him even more a prosecution witness. And we just can't kick this can down the road for close to a year. So we would like to schedule a date for Mr. Mello to either appear, be examined under oath, explain the consequences, which the court, again, is probably familiar with. He was contacted by the complainant during the alleged crime repeatedly, 4 or 5 times over the course of that day. Instead of the police being called, he was an ear witness to these allegations. Respectfully, he needs to come in here, answer these questions so the court can issue a decision as to whether he's going to be allowed to continue or whether we can go through the process of subpoenaing him and any other items that might be of assistance to us with calling him for witness.
All right, here we go. So just to kind of finish what I was trying to say a second ago, let's hope that I don't get booted off again. But on the night of this alleged incident with the fake victim with the initials of LG, Aidan was very enthusiastically and relentlessly invited to her apartment. Okay? He shows up begrudgingly and against his better judgment. And during the events of that night, this victim, who claims to have been assaulted, did not contact the police, did not call 911, and was, in fact, which can be proven through the recording that Aidan took that night, was trying to keep him there at her home rather than let him leave. But she was on the phone through that night, on and off, with Ken Mello. And what lured Aidan to even come to the house in the first place was a summons for what turned out to literally be this event that hadn't happened yet. Lindsay Gaetani was named as a witness in a charge against Aidan. And the charge ended up not even having occurred yet, is what is being referred to right now. So when it was discovered by Bederow, Broyles, and Aidan Kearney that Lindsay Gaetani and Kate Peter and Ken Mello had all been communicating with one another since before this supposed incident. Oh, yes, totally as well. Thank you, Mizzy. So all these people had been in contact with one another, which makes all this discoverable, which makes Mello a factual witness in the case, which means he is disqualified from being able to be the prosecutor.
Well, he certainly should. He certainly should be. And I'm going to say that I am writing a story about what occurred probably just prior to that night this week. Some point within the next couple of days, you should look out for it. And there is some bombshell information that will be coming out. So I just I'm going to tease that and throw that out there. But surrounding this, and kind of as a way to provide some evidentiary value to what we're hearing about there. I do have a story coming out. I've had a source on this topic for a while that isn't obvious as to who the source is, but I definitely have some information that will be coming out this week that's going to kind of blow part of that wide open. I just want to throw that out there.
Everybody, if you don't follow Jason on Twitter/X, his username is H as in Hector W on your case. HW on your case. So please make sure you follow, if for no other reason, so you can get notified when that story comes out.
Can I inquire if Mr. Mello is on?
Attorney Mello?
Can I approach?
Of course, come on up.
We have made a series of discovery demands from the prosecution ranging from October of 2024. As of this date, not including whatever was filed today, we have made 4 very thorough, detailed discovery demands sourced regarding contacts between a civilian named Catherine Peter and the state police and the district attorney's office regarding her very unique relationship in all matters involving Mr. Kearney. Those demands, which again are in the files, Mr. Cosgrove has them outlined in detail, her frequent contacts with the state police, with people that are prosecutors, statements that she has made under oath in court proceedings stating that she helps authorities get Mr. Kearney, voice recordings that she has left Mr. Kearney indicating that she provides information to them. So we have asked for any discovery related to Ms. Peter going on about a year. Now, today, for the first time, we are admittedly getting something that relates to her communications with Mr. Mello. I'll only note that all materials that relate to Ms. Peter and the prosecution were ordered by the court in early May to have been provided within 20 days. That didn't happen. We got stuff today. That's fine. But the real issue here is that in light of the change in Rule 14 from last March, the game is very different than it might have been before in terms of what the prosecution is obligated to do and what I don't believe they've done in this case, which is go to every member of the prosecution team, which is everyone in the district attorney's office, any of the state police who are involved in these matters, which includes Michael Proctor at the time, Yuri Mechanic, Lieutenant Tully, Fanning, there's a whole list of them. The Karen Reed prosecutors who are also covered, who got a little bit involved, as the court is aware, in Mr. Kearney's case, and may or may not have had a relationship with her too. She has made statements allegedly indicating some involvement in that case. The rule requires the prosecution, whether they credit the information or not, to contact each individual that is on the prosecution team and make an inquiry and find out whether there is any material and disclose it. We don't think that that has happened. We respectfully submit that is something that Mr. Cosgrove has to do. In particular, I would.
So guys, there has been an update to Rule 14 as far as the new criteria of what the prosecution has to not just turn over if they happen to have it, but now they have to make more of a deliberate effort to find any material that may or may not be exculpatory, Brady, and all that. So that way
Right.
There's not a bunch of, oh, well, the police department had this, but the prosecutor didn't have it in his or her possession. So the defense didn't get it for ages, that kind of stuff. Kind of like the excuses we received about the Sallyport footage in the Karen Reed case. It was a whole bunch of, well, Proctor went and picked it up from here and dirt.
This retired detective had it on his hard drive, his portable hard drive, and
yeah. So it's to prevent that kind of mess.
Well, and it's not just it's not just a mess that happens unintentionally. Sometimes this is exactly what they do to hide evidence and to bury things and to not, we've all heard of cases where they dump so much discovery on things that they hide things in plain sight. The other way that they do this is, oh, well, yeah, this person over there had it, but we had the discovery obligation. They didn't. We didn't have it. We didn't have to turn it over,
Right. This
And
takes
now
all
they
their
do.
plausible deniability and shoves it right back up their rectums. So
Yes,
now they have
it's an affirmative duty now for them to do that. That's
Yep. So this is something that Bederow has gone well out of his way, not just today, but in some of his letters and motions in the past, in this case. And so this is probably not the last that we'll hear from Bederow about this, but yeah, that new obligation is highly relevant here. So Cosgrove won't be able to shrug his shoulders and have that plausible deniability anymore.
Draw the court's attention to testimony that was given by a member of the state police in February of 2024, which led to a wiretapping charge against Mr. Kearney, in which Fanning of the state police stated under oath that they received a recording, a 30-second recording from Catherine Peter, that it was given to Lieutenant Tully and then given to Fanning, and we have no evidence of that. We don't have a copy of the recording. We were given the wrong recording in that regard. We have no police reports. We have no communications. We have nothing. If they don't exist, they don't exist, but they're obligated to look for it, make the inquiry, and report back and say whether any of this exists or not. And the last thing I'll note on that point, under the new rule, it doesn't matter whether the prosecutor credits any of this, thinks it's nonsense, thinks it might be real. They're obligated to do it, and we simply ask respectfully that the court instruct the prosecution to do that and disclose whatever evidence ought to be disclosed, or make a statement on the record that there is nothing to disclose. And if that's the case, then we'll all live and die with the consequences of that statement.
So this is important. What he just said right there.
Yep.
So what he said there is he didn't say. He said, make them come and make a statement on the record, and we'll all live and die in the consequences. That's the warning shot across the bow right there. Because what he's saying is he's daring them. Go ahead and come forward and say that you don't have anything else. And so in lawyer speak, what he's telling them is, we know you have something else, and we likely know what it is. So you haven't given it to us yet. If you don't give it to us, then come out and say to the court, make the statement to the court under oath then that you've complied with your thing. And then we'll live and deal with and die. We'll live and die with the consequences.
It's so nice to see how Bederow has this way of poking at you in a way that is, so held back, so appropriate, but at the same time, he leaves no stone unturned.
No, it's masterful. It really is. It's watching him is masterful. He knows exactly what he's doing.
Mm-hmm. He definitely.
I was saying I'm still triggered because that account is just so. Every time it comes up, I know the actual identity of Jimmy 2 times the original one.
Oh, right.
And I'm not gonna say it because I don't believe this is him, and I don't want to punish him any further than I already have.
But you'll never unsee it.
I'll never unsee it. Every time the comment comes up, I'm like in the back of my head, I want to be mean, and they're doing such a good job. I really don't want to be mean, but
well, yeah. I think he's proven to not be the same person.
I concur.
Is that part of the 5,000 pages that you turned over?
It is. Among the things turned over is the email from Catherine Peter to Brian Tully providing that 30-second.
Gotcha. Okay, that's fine. So that's what you saw that. You said that you had something.
So what he's...
Yes. So
okay.
This will be an opportunity.
Real quick. So he just claimed that this 30-second recording was part of the discovery dump from that day. Am
I don't know if that's true or not. I haven't had any conversations because it's currently impounded. That's the one thing I'll say that Aidan's really good at and his team. Mm-hmm. If something is impounded, I'm not getting it from them.
Well, he did say in his show though that statement was bullshit.
Right. So he can talk about the existence, whether it's true or false.
Mhm.
He can't disclose, obviously, if there's a recording, he can't disclose the recording. There is no impoundment from talking about whether they met their obligations or not, you know.
Correct. But he did say, though, that Cosgrove is not being, you know, the most honest
Well,
in
that
that
makes sense.
statement. So we shall see. And I think Cosgrove also made that statement because remember what Bederow was just asking a moment ago. He was asking for the judge to give a direct order to Cosgrove about turning this stuff over. So what does Cosgrove say? Oh, well, I've already done it. It's to avoid that order.
Did he say I did it, or
no
did he
need
say
to-
I believe? Did he say I
Well-
believe? I don't remember the wording. Did he say I believe?
Let me go back. But I think it was to avoid the requested instruction that
You could be
Bederow.
right. You could be right because it lets him off the hook.
Exactly. It's going to prevent Doolin from giving that instruction.
Providing that 30 seconds. It's largely been done.
Oh, I need to turn the captions back on now that I'm... Okay, I've got the speed where I wanted it. Sorry, I guess when it closed my page, it shut.
Maybe it was Maybe it was the captions that did it.
We'll find out.
Out of the 5,000 pages that you turn it over?
Okay.
No, it's largely been done.
Yeah, it's largely already been done.
Out of the 5,000 pages that you turn it over?
It is. Among the things turned over is the email from Captain Peter to Brian Tully providing that 30-second clip.
Gotcha.
Okay, so he has specifically said, without a qualifier.
No. The email that he said the email's been turned over, and this is lawyer speak here again. So he said it's largely been done. There's the qualifier, largely. Mm-hmm. And then when he says the email's been turned over that she provided to Lieutenant Tully, she sent to Lieutenant Tully providing that 30-second clip. The email that she sent to Tully provided the 30-second clip, and he's saying the email's been turned over.
That little shit. Let's hear that again.
The email from Captain Peter to Brian Tully providing that 30-second clip.
Gotcha.
Son of a biscuit.
The email that she sent to Tully provided the 30-second clip. He never said that they turned over the attachment. He just said included in it is the email.
Yeah, in which she was providing Tully with the, oh man. So
and I can tell you that but I will tell you is from what I saw with my own eyes that day after that, I did see that the materials were printed paper. So,
so there's no
I don't know what
there.
I don't know what else was turned over, but the materials that I saw being reviewed, and it was completely as a result of my eavesdropping in terms of where my eyes were looking at one given moment. The materials that were being reviewed were printed paper, but go ahead.
Well, and again, my belief is that everything he just said there was to avoid that court instruction.
Could be.
That Bederow requested.
Okay, that's fine. So that's interesting. You said that you had something.
Yes. So.
Oh, this deserves a video. The super chat video. Thank you so much, Krista. I appreciate it. Britt, you were adorable. Jason, thank you, by the way. Jason, after your stream on LTL and with the lovely Britt, you have a new sub, Free Turtleboy sending love. Thank you, Krista.
Yeah, thank you so much, Krista.
We appreciate it. Yeah, and guys, Jason also does have, I want to mention before I forget, Jason has a YouTube channel as well. On Your Case Media is the name of that channel. So please make sure you subscribe. He has so much back channel information that he is given on certain witnesses in this case.
Come on. You're killing me. This is listen, whoever you are, just text me and tell me now. Like, come on. This is one of my friends.
Not Jimmy 2 times too. Oh my gosh. I'm eating this up, guys. But yeah, Jason gives a lot of fantastic information about the Aidan Kearney case as a whole. So if you're not subscribed, please make sure that after this stream you go and do that. Java Time says, cannot wait to see the new Bederow letter. Hope it's shared tomorrow. It's coming, man. Bederow dropped a cliffhanger nugget this morning of a set stage and a little spotlight. And so
right, it looks like an interrogation.
It does.
It looks like one of those interrogation rooms.
Or like a solo vocalist is about to walk up and, you know, start some Freddie Mercury or Luther Vandross. So, on your case media, Kristen.
I actually think it's just on your case. Let me check. It's at on your case. Okay. Capital O, capital Y, capital C. And I only have a few videos up there, but that's also something that's gonna quickly change. So we have some more video content coming quickly. So it's at on your case.
I will add
not Jimmy. You can only come if you change your name. I'm just telling you right now.
No. This needs to continue. I'm enjoying it too much.
You're gonna be the first block on my channel. All right. Sorry. No, you will not. You will not. I appreciate it.
I'm loving this.
This will be an opportunity, Your Honor, for myself and Mr. Bederow to do an absolute 180 on our positions on disclosure of impounded documents. Your Honor will recall that the last time we were here, attached to it.
I can't believe he's asking for this.
Was an affidavit. And at that time, it was initially filed provisionally without hearing from the Commonwealth. Was impounded upon, I believe, not the affiant's representation, but I think Mr. Broyles' representation that the affiant was in fear that there would be some sort of retaliation by the Commonwealth. I think Your Honor will recall fairly outrageous, if I can put it that way, representations that were made by the affiant. I believe now, as I moved at the time, that affidavit should either be stricken or that the impoundment order should be lifted. I don't believe in the affiant.
And guys, if you follow the Young Jerks, Mike Crawford knows this person. Mike Crawford is actually the one who directed the affiant. I'm not going to give her name. I do know it. But Mike does know her. Mike actually helped connect her with Aidan and his attorneys. And after this affidavit was submitted, she went through real witness intimidation. So if you want a pretty little picture of what witness intimidation actually looks like, wait till you hear how Bederow responds to Cosgrove here.
Should be allowed to accuse an assistant DA.
Hey, Maza.
District attorney of having secret meetings.
Glad you're here.
All these other things, and then hide behind them. Okay. We get the rest of this.
Yes, a couple of things that I think ought to be corrected. The affiant is not alleging what happened. The affiant is alleging under oath that she was told by another individual who we were discussing earlier what happened.
Mark.
That's the first point. The second point is that document was attached as an exhibit to a discovery demand. Discovery demand number 4, alleging more reason to believe that there is an obligation for the prosecution to look into possible discovery that is in their possession, custody, or control. If that affidavit were to be stricken, that means literally nothing. They are still obligated to do whatever it is they had to do. And at the time that motion was discovered until 20 minutes ago, absolutely nothing has been turned over regarding this person who brags about working with the authority. So I don't know the relevance of doing anything one way or the other with respect to the affidavit. Now, that person may very well have a privacy interest because the day after that affidavit was filed, her apartment was essentially covered in personal information about herself that could have only come from someone with access to law enforcement. And almost certainly that individual was subjected to charges of witness tampering, which I believe were actually under investigation. It may still very well be. I can't go farther than that. I don't know. Somebody who never did this wrote.
Did you hear that little nugget?
That's the news. And you know, and so I just want to say something. Like, one of the things that I've been watching is obviously he's referring to Kate Peter, who lives in the same apartment complex as the affiant that we're talking about there. And interestingly enough, a day ago, Kate Peter posted a tweet that said, "I'm going to give it a few more days, and then I'm going to start spilling every recent failure from DA Michael Morrissey with receipts, things that I've been holding back for months." So so what we have is her threatening the sitting district attorney, and I believe that it's related to this issue, because I think that this moment and this hearing is probably when she found out that she was under investigation for witness tampering.
Oh yeah. Class, the yoga pose of the day is the downward spiral. Take note. They're turning on one another.
Snitch on her door. So I would suggest in this situation, impoundment of her name is more than appropriate.
Okay. Just make 2 points in response. One, I don't think it's entirely true that the affiant was simply relying on recounting hearsay. If she was, I would say something about the credibility of the affidavit as well. But I seem to recall, Your Honor, that at this one point, the affiant represented that she was present when Ms. Peter, I believe it was having a phone conversation with Hank Brennan, and she, the affiant, recognized Hank Brennan's voice because she was familiar with it.
I mean, it's not a hard voice to recognize.
I know.
The identity of this person is all over the internet, and was all over the internet at the time. It was before you the other day. I don't know what the interest is in those circumstances in concealing it in court papers.
So, here's the thing.
And I'm sorry. Go ahead.
Here, I'm pausing it.
No, let it play. Just let it play.
Final answer?
Yeah, go ahead.
Okay.
Just add one thing. Yeah, go ahead.
Oh my God. He stopped
All right,
Mark
now
from
they have a
talking. Oh my God. He stopped Mark from talking and said, "Oh, wait, Your Honor, I have one more thing." And then just stood there in complete befuddlement. Like,
so this is get used to this, because this is typical Cosgrove here. There is some people, they call it sundowning, and they say there's things going on, but you realize when you are in court and you are in the same place and you're observing this, there is a legitimate concern that he's competent to be standing there. So aside from whatever may be strategic and how he has his moments where he comes out and can make a cogent argument, much of the time he's befuddled and stumbling and slow, and he doesn't get to his point. He starts one point and never makes it. There are some serious signs of intellectual decline. Let's just put it that way. And I have ADHD, right? So like here we have the situation where I know you. So here we have the situation where I might do the same thing. I might cause the pause, right? And then be like, wait, why did I stop? But I don't think that's his excuse.
No, he wanted Bederow to quit shoveling the shit on him because he was getting buried.
And since you paused it here, I'm going to say what I was going to say. The audacity to stand here and make an argument against impounding the name of a witness and concealing their name, while you're making the same argument that on the flip side, that everything that you turned over in discovery should have an impoundment order. And actually none of that relates to protecting a witness, and this does. And so to make the opposite arguments here it's disgusting. It really is like, because he could have just stood here. He could have just stood up and simply said, I believe that this affidavit should be stricken, but if you want to hold an evidentiary hearing, fine. But the Commonwealth has no objection to concealing the name of the witness, because that would have been a position consistent with the position that he just took 15 minutes earlier in this hearing, that all of this should be impounded. So only the government witnesses should be protected. That's gross.
Precisely. Only the ones who, you know, whose information we don't want getting out deserve our protection. We want no part in taking care of people who are going to maybe let the dirty laundry out, right? And that kind of blatant lack of equal treatment and equal prosecution under the law is what's pissing me off so badly, all the way down in Florida. I'm speechless about it, because he can't have it both ways, right? He can't have one person who, you know, what they say and who they are will never see the light of day, but somebody who actually is and has undergone real intimidation, real harassment, probably real threats too. Those people we're gonna keep exposed. And you'll hear this from Bederow in just a moment, but Cosgrove gave her identity in open court himself too.
He sure did.
Bederow, yeah, and Bederow was more of a gentleman about it than I will ever be, because I don't believe in coincidences anymore, and I don't believe in mistakes with plausible deniability on the part of these people anymore. So I'm not sure it was a mistake.
I was there when that happened. I was there, and there was an audible gasp in the courtroom. This was not a small thing. Like, so many people noticed it right away, and I think most of the audible gasp might have been from me, because it was so blatant. It was like no one could believe that it just occurred. And here you look at this and you see, you know, just last night, obviously, I was on with Paula Prado on LTL's channel, and you look at
You
this.
did great, by the way.
Thank you. I appreciate it. And you look at this, and do you think that Paula Prado hasn't reached back out to them to say, for guidance about what happens in the situation and what she should do? Do you think that the Norfolk County DA has stepped up and done anything to protect her, or any of the other people? No. Repeatedly, over and over and over again in Norfolk County, and it doesn't matter if it's the special prosecutor or the DA, they're all the same. You have this scenario where their only interest is in what advanced their interest. They don't care about doing the right thing for the rule of law. They don't care about doing the right thing to protect witnesses. Can you imagine how bad it undermines the jury system in order to, like, do you want to be a juror in Norfolk County when you know they're not going to protect you?
No one in their right mind would want to be a juror if they didn't feel confident in their own anonymity, if needed, in a situation like Paula's. And I hope and pray that, one, Morrissey is given the boot, okay? And two, even if it's long after the fact, I don't know what the statute of limitations for that kind of thing may be, but whoever sits in his seat afterwards looks into what is happening to this affiant and what is happening to Paula, because that is what real intimidation looks like, what real harassment looks like. Not walking up and asking difficult questions or writing an article that says something about you that you might not like, or saying something that maybe embarrasses you a little bit or hurts your feelings.
That's actually, yeah, sorry. It's actually what I love about Paula.
Difference. They're going after Paula's family, for crying out loud.
And it is what I love about Paula, is that most people aren't good at differentiating between that, because let's face it, if you weren't if you weren't popular or a personality prior and suddenly you have this newfound fame and you're getting these attacks, it doesn't feel good, right? Like, so when people are saying that she's fat, people say, you know, people talk about that I have a lisp or whatever else you're going to do. They're needling you on all these things. That all doesn't feel, I don't care at all. But I can see that if you're new to this where it doesn't feel good, but she can differentiate between those things. She handles that so well as someone who was not accustomed to that kind of bullying. She handles it with humor and grace, and that's amazing. But
It
she
is, but she
also
shouldn't have to.
No, but she supports the First Amendment aspect of it, so she doesn't care that people are calling her name. She doesn't care that they're calling her press piggy or whatever else. She doesn't care about any of that. That to her, she can give it, she can take it. It doesn't matter. It's that other harassment that goes beyond that she deserves to be protected from, and so does the Effie in this case. And to have the Commonwealth here making the argument. The one difference is that Paula obviously came out on her own and made herself not anonymous. So we're making an argument about a sealing order or an impoundment order. So it doesn't apply to her in that way, but I meant every other word about the rest of it.
Right. The intimidation, the threats, all this. Oh, and I mean, may I just say blatant slander too? I mean, I'm not going to get into it, but
libel, sure. There's all kinds of defamation going on here, and I do think that just what people don't understand is that. So if anybody watched last night, and if not, I certainly hope you do go back and watch LTL's live stream from last night. We did have this idea where Morris Beaver, that's right. We did have this idea where, like, there are things that are happening ongoing from that. And all I can say is that is a multifaceted approach. So whatever is happening in response to this, whatever Norfolk County didn't initially do on their own to do this, we're doing it tenfold, and we're doing it in multiple different directions. So there is some of it criminal, some of it civil. There are things that are happening. And so if you're one of those people that's out there crossing the line from protected opinion and criticism to defamation, then you're on the list too. If you're one of them who is crossing the line even further and who is making threats and who is actually, committing behavior that's not protected by the First Amendment, but is also even more so criminal, you're on that list. You're near the top of it.
Oh, I'm glad somebody is doing something about it, because I don't know if everybody caught what you insinuated earlier, but what Jason was saying, guys, without really saying it, is, and please correct me if I'm wrong in this, but Paula has reached out to the authorities about some of the people who have attacked her unlawfully, who have threatened her kids, who have done all this stuff to her.
I just want to be
turned.
Yeah, let me just be clear. It wasn't quite. It's not as they give them a juror helpline number if something happens, and they were and when she called for, it was more for advice of like, what do I do in this situation? They didn't offer to do anything specific other than direct her to other local law enforcement. So that's where we're at. So, but my point is the court, especially because they're still taking action on sealing orders and doing all these other things, the court should be taking an interest. And don't tell me they don't know. I'm sorry, but so many people in that courthouse are following every aspect of this on social media. I will tell you, I have to be kind of generic here because I'm protecting somebody, but there is somebody that one day showed up in Dedham and was identified by name, had a conversation with the Mass State Police outside to ask them a question, and they repeated her name to her, saying, "Oh yeah, you posted this. We saw your post on social media, and we've been capturing all of the social media content around this case. So this is a stranger who walked up to ask a police officer for information and had her name repeated to her despite not giving it to them, saying, "Oh yeah, you're so and so." Like, can you imagine where we are in a country where you walk up to an event like that and the police officer knows your name before you
and
ask them an innocent question?
And even if you haven't posted anything, they took note and interest and were told to keep a specific eye from what I was reading at one point before the trial started, before Karen's trial, I'm sorry, is that even if you are a member of the Justice for Officer John O'Keefe Facebook page that Nick Rocco runs, if you're a member of that group, then they know who you are and they were told to watch out for you.
Well, it's interesting that you're saying, yes. Well, here, let me, all right. Well, let me just give you a little bit. We're breaking news here tonight, and I really wasn't intending on it, but let me give you a little bit of background, because if you go back a few weeks on my Twitter account, you'll notice that I identified an individual that was prior to only known as Biff Thundermuffin, and Biff Thundermuffin was basically one of Kate Peters' right-hand men, and Biff's role in all of this is that Biff has, through different Python scripting and things that he does, he's created this archival system. They're probably capturing this show right now, as a matter of fact, and that's what they do. They capture these shows when they're live. They automatically grab them and they store them in this. They store them in this database that at one point was 60 terabytes. I think it's way more now. So they are doing this to, I think the number that they said is like 130 different YouTube shows, but they're not just capturing YouTube shows. They're capturing comments on social media. They're capturing both on Facebook and Twitter, TikToks, all of these things, and they're aggregating them. And so that they can, at a moment's notice, say, not Jimmy Two Times said that he works for New York State at 10:58 p.m. on this thing, and look, we've tied that to this other identity over here, and they can do all that, and that's the information. They're then providing all that information. So when you talk about Kate Peter working with the authorities, when you talk about Kate Peter working with the witnesses and potentially cataloging this stuff so they can try and give the family the ability to file civil defamation claims and do all of this, this was all being directed by this one guy. And frankly, my partners and I had been working on it for quite a long time, and we've had the identity since January. And the only reason that it wasn't spilled out sooner is, once you know, we like to watch. And not only do we like it, it takes the discipline to do this, but not only do we like to watch, that, you know, we had people inside, undercover, in their group chats, in their discords, doing things, uncovering more identities and putting pieces together. And so as not to compromise, it's blown now, but so as not to compromise those people, it was a matter of waiting. And the reason that we changed that strategy, because we probably would have waited longer, the reason that we changed that strategy is these people coming out and using that information to attack the jurors. We're going back and looking at the archive to try and do this. And those are the exact words you hear Kate Peter use, using archiving tools. When she says that, she's talking about John Holland, formerly known as Biff Thundermuffin. So that's
our wizard behind the curtain then.
So it is interesting that while all of this is happening, how all of this ties together and that it's all related. So when they're talking about this woman, and we have Mark Bederow saying that they definitely have information from law enforcement based on what they put up on her door or whatever else. Oh, they have way more than that. They have every comment she's made at watching a live chat. If she went on, for instance, the JFK show, I think she might have frequently been there. Some other places like that. So they've archived everything that you're saying. And where does the line blur between these private actors doing this and the law enforcement people that they're sharing it with? And when do we move into areas of, well, this is entrapment, or you should have had a warrant, or this is inadmissible because there's these outside biased parties who are doing this? This is a much bigger, there's so much more to still come out about this, that people need to understand that it's a much bigger issue. So when we're here arguing not to steal someone's name, when at the same time you're being provided with all this information, it's disingenuous at best.
It certainly is. It certainly is. Nan says, they called my boss to complain about me and get me fired. I own my own firm. It was a pleasure speaking with them.
This happens to me all the time. This happens to me all the time. I'll get emails, to the owner of this company. Yeah, well, I'm the owner of the company. So I checked with myself and I felt like I handled it perfectly the first time. So.
And then before I continue with the hearing, Judge Mental, thanks so much for joining us for the first time. We're glad to have you with us. It's an intimate group, but we have fun here. So glad you're watching. And the word needs to get out about this case too. So please, please, please share, like, subscribe, do all the things that help boost this stream.
Things that were affixed to her door in her apartment building, which is the same apartment building that Ms. Peters lives in. And I think the implication was made at the time. First of all, that event was publicized by Mr. Kearney, the photographs of the door in question. And I guess I would just question, Your Honor,
ask the question.
Yeah, I know. His stall tactics are infuriating.
This individual's name being on the internet, there are two reasons for that. The first is because Ms. Peters identified her publicly and led to this kind of harassment. The other reason, and this was no question a mistake, but Mr. Cosgrove mentioned her name accidentally, and no question, no malintent. But
again, Bederow is more of a gentleman than I am, because he really went out of his way to not make a direct accusation of bad faith right here.
Mr. Cosgrove mentioned her name accidentally, and no question, no malintent, but her name was stated in open court, and as you can see, people watch in court, online, and whatnot. So the fact that her name had been put out accidentally through no fault, with no malintent, is not a reason. I think we just open up the affidavit to her name.
Okay, thank you all. So we have a date for, what was it, August? What was the date?
August 13th.
August 13th. And then we'll pick a date for the other issue. Am I correct, Mr. Cosgrove?
Yes,
the end of the month
now, or you want to pick it on?
Why don't we pick it on the 13th? I think that makes sense.
All right, I may have some, I'm sorry, I should be saying.
That's okay.
I may have some information about
That's
the health status at that time.
All right.
Mary just sent you
We'll
a
see you
text,
all on August
Jason.
13th. Okay, thank you all.
One more, Your Honor.
Go ahead.
Sorry. I believe we have an agreement, Mr. Broyles has responded relative to the source code for accessing the search of the devices. And he's indicated that it's the same source code previously provided to Lieutenant Tully, and that he would supply it again if necessary. And I've indicated to him that that's appropriate, and I think he should supply it today.
Sure,
And I don't think
Mr.
there's a disagreement with that.
You don't disagree with that, do you? Sure. All right. I'll see you August 13th.
Thank you.
All right, take care. Bye.
Of course I don't disagree. I already offered to do it. Praise the Lord.
Thank you, Mary. I had that. I already had that too, but thank you for sending it.
Awesome.
Yeah, it's great. So I think that there's so many things. I want to roll back for a minute because I actually wasn't keeping up, but Jimmy 2 times in the chat when he talked about, I only saw it when I was scrolling down when he talked about
his job.
Yeah, about them calling. And prior to that, he talked about, you don't even need to put it up because he talked about where he worked and how they called the executive director and all of that.
I see it. I see it.
This is the stuff that, just like they have all this coordination behind the scenes. If anyone goes and looks at my timeline on Twitter from today, you can see there was a lot of back and forth about Kim Fair, and you have all of this coordination between these trolls, and it's starting to come out where we're starting to make these connections where there actually are things where people can take action. But there is all of this stuff that's happening where these people are working together to try and go after people in real life. They are trying to do damages. And so I
for a
do.
long time.
I like that, but there's something even more specific now where it's more organized, like they're being given assignments almost, is what it feels like. So we're not Jimmy Two Times says that it's good that he's in the union. I love that because he's got some inherent protections, but we're in the situation where that's not true for everybody, and it's not true for Paula because that is exactly what's happened to her, where somebody has got into her real life and they're either affecting her future job prospects or the existing jobs of people in her family. And for what? Because she was one of 12 jurors who had a unanimous decision on a verdict. Like, it's ridiculous.
Because she was called upon to perform a civic duty and she answered the call. I mean,
right. And when I get the calls, I don't care. I get harassed, right? I get the calls, I get the emails, I get the direct messages, I get the public comments and all of this. I was getting pizzas and Chinese food for a while that I couldn't eat because I was afraid they ordered like the worst combinations or ingredients.
You're a background photo on a lot of people, or at least your house is.
Yeah. Oh, yeah. He switched it back today. I was actually having a conversation with someone before I came on because I was going to make my background. This is Hartford, Connecticut. I was actually going to make my background the Cumberland Farms where he got arrested or whatever. We're from an incident. But I wasn't going to say anything. I was just going to do it. But you have all of this. When you have family members of the most prominent witnesses in the case going after jurors, like it's all something's gotta give, and like people have to calm down. And I don't care about the online opinions or whatever, but other than that, like these actions of trying to reach out into people's life, it's definitely actionable. You know what I mean? So whether it be civilly or criminally or whatever else, like if you're taking steps to attempt to get somebody fired because they expressed an opinion on social media, I don't think people understand that that is actionable. In a lot of states, it's criminal. It's like criminal harassment to a certain level, just like some of the forms of doxing that are out there are. So people need to be smarter, and I think it's going to take some examples. So I'm in the business of providing examples right now, and that literally is how I'm spending almost all of my time. That's not spent sitting here answering questions, is working with people behind the scenes and helping put these cases together. And that's something that you and I should talk about with our current commenter. Maybe we can set up a time to do that because that's something that we should put together.
Absolutely. Absolutely we should. Scott says it was great seeing you the other night.
I love that. I already mentioned that dive bar gathering because it was Tim's birthday, and I always love every chance I have to run into my friends, including Scott. So
wonderful. Now, Jason, I've already taken 2 hours of your time, but I did mention possibly going over Karen's civil team. If you would like to stick around for that, feel free. If not, please excuse yourself. It is 100% up to you.
No, I definitely will.
Okay.
Because I think that I haven't kept up with this, so I'd like to see who it is. So
okay.
This will be news for me.
So, as we know, the first 3 attorneys that Karen had for the civil case are from the firm Mellick and Porter. Okay, so these are the ones who've been there since the original filing. I think they're adorable. First of all, this is one of them that I'm looking forward to seeing in the courtroom the most. William Kelville Jr., who looks like he plays the accordion or maybe some other unusual instrument. He just seems precious. He seems like he's probably got good courtroom connections, maybe plays golf with a judge or two here and there. I have a great impression of him just from this picture. I like him. Now, I don't know much about any of these attorneys' backgrounds, but he is the senior guy at Mellick and Porter. The second attorney who's been there, pretty much from the jump, is this gentleman named Christopher George. And if I'm not mistaken, Mellick and Porter is retained by Karen's auto insurance company. So this is one of the other attorneys. Nan says we likely won't see this in the courtroom. That would be sad. I'd like to see at least some of it on video. I would love, I know that a lot of the depositions are kept private, but God, it would make me so happy to.
Well, there's also, I think what Nan might be referring to as well is there's also talk about there being some sort of settlement, especially in regard to whether there was an auto accident or not and everything. Maybe not. I don't want to speak for Nan. But that's been the talk.
Are designed to settle. I mean, I get it.
But that's been the talk that I've been hearing over the last few days. So.
I see. Well, let me introduce to you this little Spitfire. She is adorable. She's the third attorney from Mellick and Porter. She is so cute. But I feel like at the same time, you need to watch out for her. Don't let her cheerful appearance fool you, because she'll take you to school. Okay. So this is Marissa Palladini. Another one of the.
She could be the Camille Vasquez of Karen's civil suit.
That's what I was kind of. That name popped up in my mind when I first saw her. I'm sure that she was valedictorian somewhere and captain of, this, that, and the other. She's just got, a graceful smile, but fiery eyes. She was a born leader. Okay. So watch.
I think that's how we hear about Elizabeth Little as well, right? It's the same concept where she looks like this, cheerful, nice girl or whatever.
Mm-hmm.
But in reality, she's a killer when it comes to practice,
Exactly. So watch out for Marissa Palladini. All right. So next. So these next three attorneys are not part of the Mellick and Porter firm. Sorry, I said film. These three attorneys were brought on later. One of whom, the first of which I'll go ahead and bring him up now, is Damon Seligson. You may or may not have already seen this, but you can actually watch an interview that Seligson did with Larry Foreman, the DUI guy, last week, if I'm not mistaken. Seligson was initially brought on to help represent Bill and Janet Reed, Karen's parents, when it was when they were supposed to be going in for depositions. And if any of you were paying attention at this time, before trial number 2, Damon Seligson was instrumental in getting the judge in the civil case to put a stay on Karen's deposition as well as the depositions of Bill and Janet. So at least until after her criminal trial. And Damon probably had a sneaky suspicion, because he knows Hank Brennan. In fact, he went to law school with Hank Brennan, that Hank Brennan would probably use whatever Karen said in her deposition against her in the criminal proceeding. So, Karen's family was highly impressed with Seligson's cunning and performance. So he now has been brought on as more of a kind of representing both Karen's parents and Karen. And he has taken more of a higher role, so to speak. So that's Damon Seligson. Next, we have Charles Waters, who I know absolutely nothing about, and this blurry photo was the best picture I could get off the internet of him. But he is listed as part of the civil team. And then here is the male version of Marissa Palladini. It's this guy right here who I couldn't begin to try to guess his age. Like, he seems so youthful, but also so wise, like the Last Airbender, like Avatar, the Last Airbender. And his name is Aaron D. Rosenberg.
I lost one of my earbuds somewhere along the way.
Oh, yeah. Sorry. But that's him. He is a business litigator as well. And then in my preliminary research, and, you know, as I find more, I will obviously be dropping more nuggets. But Melville, this guy, the one who I think plays bagpipes or the accordion or something.
Bagpipes. I think bagpipes are even better than the accordion in this case. Yeah.
I'm just saying, I feel like he plays an unusual instrument. But Melville, out of everybody who I looked up, seems to have the most personal experience in his career with wrongful death suits. So he's definitely going to play a role. Thomas says he looks like Gilligan.
I wonder if these lawyers have know that we have like a fantasy football thing going on around them. Like, if they don't even know, like, that they're out there and people are speculating about them based on their appearance or this, or, you know what I mean? Like, we're like, this is how you know we're really law geeks, is we're sitting here speculating on a civil team who hasn't even really basically started their work yet. And we're it's like Big Brother. This is our Big Brother, you know.
It really is. Fantasy football. I love that. And of course, as we all know, Jackson, who has said that he is never going to not be Karen's attorney. So
yeah,
I'm sure he'll get a call from Karen here and there with all this. So, oh, I lost the chat I was going to bring up. Here we go. Annie from Southie, welcome. I'm so glad that you joined us tonight. So judgmental, that is kind of on a case-by-case basis. And then,
I do think that most of these cases, even though they're not televised, they should be public in terms of your ability to go sit in the gallery.
Right. And in terms of reading what pops up on the docket, in my opinion.
So much of the work happens in these civil cases, especially these large ones, out of court, though, where it's, you know, that's exactly right. It comes down to reading the docket because much of the case is argued via paper. And, you know, while there could be a chance for obviously oral argument or examination of witnesses or things like that, it's not all of that is all done initially also by deposition, and the whole civil system is geared toward resolving these cases, not toward necessarily, you know, in a criminal trial, the person's liberty is in jeopardy, and there's a kind of a defined period of time that it should take to get to trial, and trial should be, you know, it's a completely different world.
Right. It is. But given the public interest, something tells me they'll allow more than maybe your typical civil case to get out there. So we'll see.
I guess we'll have to see. That's right.
And then the prognosis from Seligson, if you missed his interview with Larry Foreman, that's this guy right here, who, by the way, has an accent, and I love it. I really like his accent. It is not a Bostonian accent. It's European of some kind. And his prognosis is that if it goes to trial, and he actually seemed confident that this would go to trial, at least in that interview, he kind of took the position that they would be assuming liability for nothing because Karen Reed was not responsible for John O'Keefe's death. And it's that simple. And if that's the case, then I've got my pom-poms out. I support them. But he seemed like, if they needed to take this to trial, they would. But it would not be until 2027 or so that
and that's certainly the position that he's going to take at the beginning stages of the trial, because that's
right.
There's a certain amount of posturing that you see happen, but we'll see what happens along the way. I personally don't think that they should, but sometimes when an insurance company is making the decisions and calling the shots, there you go. Oh,
yep,
look at that.
There you go.
Whoa.
Man,
I love
here
it.
to assure us all.
I love it. And that's what happens. So sometimes when that happens, they look at the cost of protracted litigation and other factors there, and they don't care.
Right.
They don't care about whether,
they
at the
weigh
end of the day,
and balance all those things. And yeah, I hear that. Oh, Annie, I am not saying there's anything wrong with a Bostonian accent. I was expecting a Bostonian accent from Seligson because, he has a firm there and he has lived there for quite a while. I'm assuming because he went to law school there as well. And so I was expecting that. And then what I heard was it just threw me off. It was completely different. So yeah, make sure, Annie, that you watch that interview. It was very good. Larry, the DUI guy, did a fantastic job. So, but that was all I had for tonight. Judgmental says it almost sounds Irish. Maybe I can't put my finger on where it is, but he has like a Scandinavian name, which remains in mind for me when I'm thinking about where his accent may be from. But that was all I had for tonight, Jason. So hey, I really appreciate your time. Thanks so much. I always enjoy chatting with you and shooting the shit about the bullshit.
Yeah, we had a good start, and I think from there it's only gotten better. So
it has. Well, great seeing you again. We'll do this again very, very soon. But y'all need to go to bed, and I need to eat something. So
me too. That's all I can think of is I'm hungry. I want to go eat.
Yeah, I got stuck behind a car accident on my way home from work today, and I basically walked right in the door and turned on my computer. So but thank you to everybody who tuned in tonight. Looks like we've got a little over 100 viewers on YouTube and a little over 900 on Twitter X. So thank you guys so much for watching. Please stay tuned. We're going to be the next time we come on, we're going to have Aidan Kearney, first of all. The next time that we're live, we're going to be doing a fundraiser for him. So the man himself will be joining us. That's going to be on Sunday, the 20th of July. So please don't miss that. And I'm going to be coming up with a very specific outline for this case for people who may be new to it and need to catch up on the gory details of the Commonwealth versus Aidan Kearney. So y'all take care. Have a wonderful rest of your night. And thank you again. God bless all of you.
Bye, everybody.
Where's my outro video? Okay.